Hi, y'all, and welcome to tonight's live stream. In a legal case, it's entirely normal for both sides to ask the judge before the trial gets started to keep out some of the evidence. Maybe it's hearsay, or maybe it's not relevant, or there could be a host of other reasons why evidence should not come in. Maybe it's unduly prejudicial. But in the Richard Allen Delphi murders case, the state has moved to keep out virtually all of Richard Allen's evidence. He's accused of the double murders of two young girls, Libby German and Abby Williams, ages 13 and 14, on February 13th, 2017. But in that case, he wants to argue that third parties, other people, not Richard Allen, committed those murders. He wants to argue that law enforcement even thought that a group committed the murders. They never thought one person, like just Richard Allen, could have committed it. He wants to argue that some, and maybe even many, members of law enforcement believed that the murders were connected to a shadowy group, a religious group called Odinists. And in fact, so did an expert that the state hired. But the state wants to exclude pretty much every defensive argument that Richard Allen has in that area. Has the state gone too far? If the judge grants the motion, will the state wind up regretting it ever made the motion? And most importantly, will excluding this evidence prevent Richard Allen from getting a fair trial? Plus, we are going to get into some bombshell evidence along the way that we have not talked about before. It's a preview of another upcoming video where I'm going to go through some of the absolutely shocking evidence Richard Allen has about third parties. And maybe I ought to say more clearly, allegations he has that third parties, not so much evidence, that third parties may have committed these murders. So shout out and a special welcome to the first five in the chat tonight: Olivia's mom, aka Sue, Michael Lalonde, Compassionate RN, Elizabeth, and Blue Mermaid. Please be sure to hit the like button and subscribe. And if you're not a member, tonight is a great night to do it. We're going to be doing an extra members only event after our live stream on Wednesday. So we're going to cover three areas tonight. I want to talk about what the state filed. And I have a summary chart of it for you. Then I want to take a look at what Richard Allen's response is. And then thirdly, I want to talk about whether the state's motion just goes too far. Is the state making a mistake to request this? So let's start with what the state requested. The judge has not yet ruled on this. And in fact, Richard Allen's team dove in with an extra 2 briefs on it just in the last few days. So let's talk for just a minute. This is called a motion in limine. Sometimes lawyers call them motions in limine. There are several different ways to say it, depending on your area of the country. So what that is essentially is where you tell the judge, I want you to rule on this evidence before trial. One side will say, I don't think this evidence should come in, and the other side wants it to come in. And the request is that the judge make that decision before trial ever gets started. It makes it easier to do your opening statement if you know what evidence is going to be there. It just sort of helps you plan and organize the trial. So a lot of times people will ask the court for that. And that's what the state did here, filed a motion in limine saying, I need you to rule on this evidence. So what happens if you violate a motion in limine? You may be wondering that. And the truth is, it's not really all that clear. There isn't a firm rule. It's going to depend on what the ruling by the court was and who the judge is. So it could be anything from just the judge, turns to you with a horrified look and says something in front of the jury that's very embarrassing. That might be all that happens. Or it could be that the judge says, I told you this, and holds you in contempt. I mean, it could be a wide variety of things that might happen. The judge might instruct the jury, you have just heard such and such that is incorrect, or that is not in evidence. You must disregard it. It could be something like that. It's not there's no one thing that the judge is definitely going to do. A mistrial is a possibility. Usually it wouldn't be that serious, but those are the kinds of things that might happen. And There's no definite plan in advance unless the judge says so. So let's take a look at where this all started, at least in the defense's mind. Let me pull up my first document, and I have to flip back to the actual first document. This was an email that Judge Frances Gull, who has been specially appointed to hear the Delphi murders case, sent out. She sent it out on April 28th to all the lawyers in the case. And you can see it's supposed to be kind of just an overview of this is how we're going to do trial. This is kind of how things will answer, how things will work. You know, it's jury selection will take 3 days. Court will be in session. Let me make sure that my settings are correct. I'm going to make that and make this larger so you have a shot at reading it. Okay. So things like, you know, here's how we're going to do jury selection. Here, we're going to put the jurors up in a hotel, things like that. So the jury is going to be sequestered the entire time of trial. Very, extremely unusual. And of course, it's pretty expensive. But this was the part right here that bothered the defense, down here at the bottom. And she was simply referring to the fact, the judge was, how long is trial going to take? And the defense had said, hey, you aren't giving us enough time. We need more time. We're going to need a couple of weeks. And she said, I'm unaware how many witnesses the prosecution intends to call, nor on how long their case will take to present. The defense is claiming it will take, quote, a couple of weeks, close quote, to present its case. I am unsure what exactly the defense intends to present. I am quite familiar with the law regarding third-party perpetrators, and unless the defense can provide a nexus between any alleged third-party perpetrators and the charged crimes, those allegations are unsupported and will be inadmissible. So an advance shot across the bow by Judge Gull saying, hey, look, I don't know what it is you think it's going to take 2 weeks, but if you're thinking you're going to get in evidence about third-party perpetrators, just know this, I know the law, and you're going to have to show me there's a connection between those third-party perpetrators, the people who are not charged in this case, but you think actually committed the crime. There's got to be a connection between those people and the crime. You can't just start naming names. And if it's unsupported, it's going to be inadmissible. I'm not going to let the jury hear about it. So that the defense felt like was prompted from nowhere. She just threw this out there. I will say this, before I ever even read the defense motion, I thought, wow, that's weird. Where did that come from? That she's throwing that out there. And that's exactly what the defense thought too. They thought the exact same thing. Now, so the defense seems to believe that what happened was she suggested this, and the very next day, the state filed a motion saying, hey, we want to keep out all these third-party perpetrators. And that it was connected. Basically, the prosecution was invited by the judge to file this motion, and then they did. Personally, I think the prosecution would have filed a similar motion anyway. I believe that there's always a dispute over putting in third-party perpetrator evidence. It's also called third-party culprit in some states. And so I don't think it was necessarily that she invited it, but it certainly was clear that she was already thinking maybe she wouldn't allow this in, and telling the defense that. So let's take a look at what the state filed the next day. And since I've done a chart for you, I'm really only going to point out one thing right here, this part in green, because I'm going to show you my chart with a list of what it is they want out. But I want you to notice that they don't just say, we don't want this in. They say, we don't want that in if it's not relevant or the probative value is outweighed by unfair prejudice, confusion of the issues, or has the potential to mislead the jury. So you might think when you read that, oh, well, then they don't really want it out. But more or less, those are just lawyer ways of saying that by the prosecution, saying Richard Allen is going to have to prove a lot in order to get these things in. We don't think they ought to come in, and there's going to have to be a big showing of proof if he's going to let these in. And their motion is very broad. I'm going to make this bigger. So what I did was just kind of go through and list what are the things that they talk about that they want to keep out. And for some of these, I've noted that these are specifically related to third-party perpetrator. The parts that's in green is more sort of a mental note to me that I wanted to say something about it to you when we got to those. So number one, any comments about counsel for the state that constitutes a personal attack. That's really vague. I have seen motions in limine like this before, particularly when one side has somebody who's maybe a little bit more controversial and the other side may try to attack them. But it is a very unusual motion. I have seen them before. Any comment which constitutes a personal opinion of defense counsel about any evidence, witness, outcome, or penalty. Well, it is the case that you can't make comments about your personal opinions. I don't know that that would necessarily need to be a motion in limine, but that is how they did it here. Number three, any innuendo or inference that is not supported by admissible evidence. Now, I put that one in green because that is huge. Any inference not supported by admissible evidence. That is really, really broad. I think it would be very difficult for the defense to comply with that. If the judge actually entered that, I don't think they'd have a lot of notice about what exactly it is they're not supposed to do. Innuendos, inferences not supported by admissible evidence. I think that would be very hard. I think the prosecution probably had specific things in mind, but that isn't the way it turned out in the way they wrote that. Any attempt to indoctrinate the jury during voir dire by exposing the jury to substantive issues in the case. Ironically, the judge also granted the defense motion to do a mini opening statement during the voir dire. And the defense said, we want to just sort of lay out things for them to make sure they understand what they're going to be deciding. So this was kind of the opposite of that, which is don't tell the jury anything substantive. Don't try to indoctrinate them. Again, very, very vague. Number five, any attempt during voir dire to have the jury prejudge the credibility of a witness. Number six, any hypothetical questions that include facts that are not in evidence or questions that are not helpful. That is questions that are not helpful. That is a really hard motion in limine to comply with, because how do you know what the judge is going to decide wasn't helpful? What the state is going to argue isn't helpful? It's just super, super broad. Any attempt to introduce evidence of third-party motive that is not relevant and or the probative value is outweighed by et cetera, et cetera. And the same things I read before. I'll go ahead and read them. Outweighed by unfair prejudice, confusion of the issues, or has the potential to mislead the jury. Those are standard phrases that are often used in this context by lawyers. So this is everything. So this first part is any attempt to introduce evidence of third-party motive that isn't relevant, et cetera. So that's also very big. Any third-party motive leaves Richard Allen very little room. He has to show that it's relevant, that it won't cause unfair prejudice and so forth, which he will have to do. But you can see what they're aiming for. And I want you to see underneath this all of the categories that they filled in under this one. I numbered them out separately. Odinism. So that whole argument that Richard Allen wants to make, that this was a ritualistic killing, and you can see that in the next one, cult or ritualistic killing, that there were runes laid on top of the girls made out of sticks, that there was a letter written on a nearby tree in blood that was a rune, that all of this showed that there was a group that did this as part of a religious ceremony. All of that would be kept out. That's including Odinism, cult, killing, Brad, and then they start naming people. Brad Holder, Patrick Westphal, Johnny Messer, Elvis Fields, Ned Smith, Rod Abraham, and I'll go ahead and do them all. Keegan Klein, Jerry Klein, and Ron Logan. What we are going to do in another video is I'm going to pull out what they've said about those, and we're going to do a deep dive into some of the third-party culprits that Richard Allen believes might be responsible for killing Libby and Abby. Then moving down, reference to investigation by Todd Plick along with reports or investigative materials. The defense says that law enforcement itself, Todd Plick was with law enforcement, that they believed, and Todd Plick continues to believe, that this was done by Odinists. This was part of a religious cult ceremony of some sort, not Richard Allen. Reference to geofencing and testimony from Kevin Horan about geofencing, and that relates to evidence that 3 other cell phones were in the exact area, according to the defense, where the girls' bodies were found, not Richard Allen, 3 other people. Reference to prior bad acts or acts of any witnesses that plan to testify at trial. And that's a common one, but usually it really should be more specific than that, because otherwise there's not good notice to the defense about what it is that the state wants out. Reference to how the files were labeled that were handed over to the defense as part of the information and discovery provided to defense counsel by the state. And that relates to the defense believing that the state is hiding information. And reference to PowerPoints provided by the state as executive briefs involving any person or persons that were investigated by law enforcement as part of the 6-year investigation. So they're saying, even if you investigated other people and you thought they might be suspects, let me rephrase that. Even if the state investigated people, thought they might be suspects, obviously there are some PowerPoints related to the reasons why the state believes some of these people are potentially guilty. We want all of that kept out. And so, as you can see, I mean, the state has asked a lot. This is a really, really long laundry list of things that they want kept out. And so I do want to talk about first I want to get into Richard Allen's response, but I also want to talk about whether, just if you only look at this from the state's point of view, is it a good idea to do this? Because personally, I don't think it is, but we'll get into that. First, I want to talk about what Richard Allen said in response. Let me pull up in my notes. Okay, so for him, this motion is a huge problem because it's the basis of his defense that someone else did it. If he loses this, his chances of winning plummet. And so what this is basically, this evidence right here is what took him from basically everybody figured he was guilty to, well, gosh, I'm not sure anymore. Was this Odinism? Were there multiple people involved? Were there other suspects? And this was the evidence that created a renewed and larger than ever interest in this case, because it really changed the way of looking at it. So in the mind of at least his lawyers, it's make or break this particular motion. If all of this got excluded, I believe they think they would have a much more difficult time winning. So so far they have filed 3 different responses on this, 3 different briefs on this, and they also presented evidence in at the hearing. Now that hearing wasn't televised. There's not a ruling on it yet, but we're going to look at the 3 written documents that he's filed. So let's pull up the first. Okay, so the first thing he filed, I'll make it bigger for us, was just the straight up response. And I'm just going to do a little bit on this. And the second to last, and here's where they complained, look, the court put in there, I'm quite familiar with the law regarding third-party perpetrators. You put that in your order, had nothing to do with anything. Why are you bringing that up? And then the state, without hesitation, accepted the court's invitation to limit evidence regarding third-party perpetrators. And personally, I don't really think I think the state would have done it anyway. Did they file this in response to the court's comment? Maybe, but I think it would have been coming anyway. The court has established a pattern of summarily denying pretrial evidentiary motions filed by the defense throughout this case. And basically that just means the court rules against us a lot. And indeed, that is correct. The court rules against the defense pretty much every time. In contrast, the state's motion in limine contains no supporting documents, but it's really a burden shifting motion. So I'm not really sure that it needed to, but the defendant Allen's defense team is quite familiar with the law regarding the admissibility of evidence of third-party perpetrators, which requires only that defendant Allen establish some connection between the third-party perpetrator and the crime. So in many ways, they agree. Richard Allen, in order to get in this third-party evidence, has to show that this third-party potential perpetrator has a connection to the crime. It can't just be somebody random who was wandering by. So they agree on at least that much. They probably disagree on exactly what the standard is, but they do agree that there has to be a connection. So let's take a look at the next document that they filed, which was, and actually, I did think this was pretty well done. They cited back, this is after the hearing, they cited back to a hearing 2 years ago in November of 2022 when this, and talked about what the state said at the time. They said, this still is a very ongoing investigation. Our goal is to find anyone else who was involved in this heinous crime. That is the public interest, to find anybody else involved and get justice for Abby and Libby. So at that point, they're saying, look, the state was looking for third parties. The state also said, we have good reason to believe that Richard Allen is not the only person involved in this case, that there may be other actors involved. That's why we left the tip line open. That's why we left the tip email open. The question becomes, at least in the state's mind, is it more important to release the details of the investigation to the public, or more important to keep those confidential in order for the investigation to continue and find anyone else that's responsible? It puts the investigation in the best position possible to determine if anyone else was involved. It is in the best interest of the public that the investigation find anyone else involved. And then they cite two attachments that were, two filings that were made at about the same time. A letter from Detective Holman saying that he felt like the records ought to be sealed because the investigation is ongoing and fluid. And another one from an investigator saying this case is still being actively investigated. We're continuing to search and seek facts and information relating to Richard Allen and other potential suspects. So that was something that was said by the prosecution 2 years ago. So they were saying that they were still looking for the possibility of third-party culprits. And Richard Allen's team is saying it's irrational now to say, oh, it was Richard Allen and only Richard Allen, and suggest that no evidence of other people should come in when you yourselves believe that other people may be involved. So that's the argument that the Richard Allen side is making. And here's the third document that they filed. As I say, this is a very, very important motion to them. So they have taken it very seriously. They talk about Mr. Allen's constitutional rights under the 6th and 14th Amendments of the United States Constitution and Article 1, Section 13 of the Indiana Constitution to present evidence attacking the credibility of the prosecution's case, undermining the believability of the prosecution's witnesses, identifying third-party suspects, and establishing Mr. Allen's theory of the case, pointing out, reminding people, this is not just about whether or not he wants to do this. This is a constitutional right he has to be able to defend himself. When the prosecution seeks to prevent an accused the opportunity to present other versions or possibilities regarding the alleged crime, either through cross-examination or his own witnesses and exhibits, they are urging the trial court to commit not only an evidentiary error, but a constitutional error from which prejudice is presumed. And I will say in just a minute a little bit about my opinion on that. And I'm going to give you just a little bit of a preview of some of the wild evidence that is in this brief that was presented at the hearing and that is in store for the case, assuming it gets tried with all of the evidence in it. Because this is really dramatic evidence. You can reject it, you can believe it, but it's very dramatic. So they argue why they believe the crime against Libby and Abby had elements of Odinism and ritualistic killings, and cite an expert that they had. And they argue, look, in this case, the prosecution argues that Richard Allen, acting alone, killed Abigail Williams and Liberty German. However, the evidence from the location where the bodies were found strongly suggests that more than one person was responsible for these murders. And then they talk about what Dr. Dawn Perlmutter said. And I want to go super quickly into what she said, just 7 points she said, and I'm not going to go into detail about that, but she testified that the murders met all of the elements of a ritualistic killing, that it was textbook, and it included the location of the crime, which was in a clearing in a wooded area near a body of water, and it was nature-based, outside. The date of death, it was a sacrificial feast day honoring Odin's son Valus, began at sundown on the 13th and ended at sunup on February 14th. The cause of death, which was their throats, murder weapon involving knives, symbols, and I don't know what proof there is of that other than that the girls were cut. I don't know what proof there is that there were ceremonial knives. Symbols at the crime scene, that would be the branches we talked about a minute ago, and the rune written on the tree in blood. The body disposition, and the expert testified that they were positioned in a certain manner. And there was also an FBI special agent who testified that the bodies had been staged, that this wasn't just accidental. They fell there and they got left there. And that this wasn't just something where branches were put on top of them to hide them. This was very intentional. And that there were atypical blood patterns. So then Richard Allen argues that he has the right to challenge the manner, quality, and thoroughness of the investigation, to inquire about law enforcement's failure to consider third-party suspects and to present evidence of a biased investigation. So it's not just that he has the right to suggest other people did this. He also has the right to suggest that law enforcement did a poor job. And we've seen that in case after case. We have seen that argued in the Benefield case. We saw that argued in Karen Reed's case, that's a common argument defendants make, that there were lots of other people you could have considered and you did not. The fact that an investigator may have discounted a viable fact or suspect makes it more probable the investigation was flawed and that Mr. Allen is innocent. So, and now I want to skip on down because I really want to show you one of the arguments that is made for one particular third-party culprit, because it's a very strong argument. Now, before we even read it, I do want to say it's a strong argument in this sense. It's written well, and the facts, if you see them only from the defendant's side, are very compelling. There is, of course, another side to this. Right now, there's not a response to this from the state. So we're looking at what the defense has said. But as it is, with just what's written here, it's very compelling. I think you'll agree. And then there will be more to learn about what the state says. We will find that out shortly. Keegan Kline and Jerry Anthony Kline. And you saw that list as I scrolled through. There's a long list. You also saw it on that list I did of all of the people they wanted to exclude, the state wanted to exclude. So these are just a couple of a list. Keegan Kline is the son of Jerry Anthony Kline. He was 22 years old in February 2017, and he and Jerry Anthony Kline resided in Peru, Indiana in February 2017. Detective David Vito testified that Keegan Kline was communicating with Liberty German using a fake Snapchat account under the name of Anthony Schatz in the days leading up to and on February 13th, 2017. So he was actually in contact with her using a fake account on the day she was murdered. The content of these messages is unknown. He further testified that Keegan Kline admitted to driving to Delphi, Indiana with his father, Jerry Anthony Kline, on February 13th, 2017, and that Keegan Kline waited, I believe the word in is left out, the vehicle while Jerry Anthony Kline went to the woods in the area where the Abigail Williams and Liberty German's bodies were ultimately found. Detective David Vito testified that Keegan Klein stated that when Jerry Anthony Klein returned to the vehicle, he had blood on him. Roland Purdy further testified that Keegan Klein admitted that they discarded a knife in a river when they were driving home. All of this evidence creates an inference that Keegan Klein and Jerry Anthony Klein murdered Abigail Williams and Liberty German. So I'm going to pull out so we can just talk. Now, without a state response, that's really powerful. There's also a fact in there that isn't even mentioned, which is that Keegan Klein is serving a 43-year sentence for child exploitation. He pled guilty to 25 counts, including child exploitation, child solicitation, possession of child pornography, and synthetic identity deception and obstruction of justice. So all of those things were what he pled guilty to. And so, as you can see from that, it's the kind of evidence that if it's not allowed in and then the state doesn't respond to it, it leaves a bad taste in the mouth of the public because of the fact that it could be true, and we need to hear from the state about why it isn't true. There may be perfectly good reasons for that. It may be really obvious that it should not be Keegan Klein. But on the other hand, by keeping all of that out, the state leaves this case in a state of people not knowing whether or not to believe the final result because it's been left out. There's too much that got left out. And I definitely believe that the court should insist that Richard Allen make the regular proof, bring it to the standard, bring facts to the standard that's required under the law. But as the motion is written by the state, it just looks very biased. It is way too broad, and it is a recipe for getting the case reversed, as well as for undermining the public credibility of any verdict. There's just way too much out there to just say, let's just keep it all out and pretend that didn't happen without the state ever having to respond to it. That is just, I think, a mistake. I think that would be a mistake. I also want to answer another question that I saw out there on the web about, is Richard Allen maybe going too far by boxing himself in so that he will have to actually prove that these other people committed the crime, when really all he has to prove is that there's reasonable doubt about whether he did it, which is technically a much lower standard than proving someone else did it. And the person talking about that was pointing out that despite all the evidence in the Karen Reed case, the majority were actually in favor of guilty on the manslaughter charge. The majority of the jury, they were apparently united on not guilty on the other two. But in the middle charge, the manslaughter, they were the lesser included offenses, they were leaning toward guilty. So my personal opinion is Richard Allen is not making a mistake by wanting to put this evidence in, because I think this is how he will prove reasonable doubt in his case, because the lack of connection for him to the crime means that he really needs a different way to show maybe someone else did it. And I think this is how he would do it. So I think he's correct to want this in. I think the state ought to let up, and I think the state ought to let more in as well. So we are about to move into some questions. If you have a question, would you put question marks at the beginning, and it'll be a lot easier to spot. This is a super, and let me just say a few things as we get started. This case is absolutely fascinating. It is unbelievably interesting. Now, we don't know I don't. Let me rephrase that. I have a lot to learn still about the case. I'm getting into it. I know there are people who have spent years learning about this case, but it is fascinating. And I think it's really important because of some of the principles about when the state ought to allow the defendant to make proof, when the state ought to step up and show that the proof is false. Whether or not Richard Allen has been treated fairly while in custody. These are really important questions. I depending on the interest level in the case, I've definitely considered going to Delphi, Indiana, where the trial will be, to see the trial and to report on it live. It's not going to be broadcast. It's not going to be televised. So this would be the only way I could really do that. I do think it's a really, really important case. So if you would be interested in that, let me know. And I will look forward to reading that. Okay. So I think I went far enough back. Somebody asked me, well, I saw someone ask me, what do you think of the judge? And I don't really have an opinion about the judge. I can definitely say she seems to rule against the defense. She does not like the defense. And the defense has tried repeatedly to get her off the case, which is definitely a recipe for making the judge hate you. So you have to be super careful using that. But they obviously felt like it was already a lost cause. I really disagreed with some of the decisions she made about keeping things under seal. For example, the pleadings are not made public in this case. You can get them, but they aren't just put on the website. They aren't made public. And I think that's a shame. I also think it's a shame that it's not televised and that pieces are televised. For example, the hearing coming up in the future, a little over a week, I think, is going to be partly televised and partly not televised. I don't know what the reason for that is, and I don't know which part will be televised and which part won't be, but I would like to see it a more open courtroom. So that is my impression. All right. Michael asking, how was my weekend? It was good. Thank you, Michael. I appreciate your asking. Now I'm at a loss to think of anything that I did other than take a walk. I did do a lot of decluttering. Anybody else into that? That was actually super hard. Okay, Mickey Bassett. It seems that Judge Gull has been extremely biased against Richard Allen from the very beginning. Does this give him grounds for an appeal, and can Gull be censured? So, Mickey, I don't really see this as something related to Judge Gull being censured if she grants this. I don't picture that. And the appellate court has made it clear that it's not going to take her off the case. So she's the judge for trial number 1. But what I think it could do is lead to trial number 2. I think if this is too broad, it makes it so much more likely that the case gets reversed on appeal. That's something nobody wants. So the judge really doesn't want to push this to the edge where she keeps out everything. I don't think the prosecution should have even asked to keep out everything, because it makes it look unfair. And it means that the appellate court is going to come in and going to review this and think, gosh, nothing? I mean, every single thing he wanted to do, you ruled out. And that's pretty close to what that motion says. It is really broad. And so for that reason, I think that's a mistake. Olivia's mom, aka Sue, asking me, how is it that RA's, Richard Allen's 8th Amendment rights haven't been completely violated? There are people on his side who think that they have been violated. So I think that we'll continue to hear more about that as time goes on. Lisa H., how about the confessions? He confessed to his wife. I think he did that intentionally to keep it out by spousal privilege. Lisa, that is something that people have talked about. But it wasn't just to his wife, it was also to his mother. And he doesn't have spousal privilege with his mother 61 times, something like that. I saw different numbers, 61, 62. After a while, it's a whole lot of confessions. And it wasn't just to the wife and mother. It was also to jailers. It was to the prison warden. It was to various people. So the defense argument about that is, okay, yeah, maybe he confessed, but he only confessed for a 2-month period. He adamantly maintained, I didn't do it. Then he was drugged within the prison, and essentially they would call it tortured. He was treated terribly within prison, and he lost his mind, and for 2 months confessed. And then when he regained his mind, then he stopped confessing. And so they believed that these were coerced, that he didn't confess because he really believed he had something to confess to. He confessed because he went nuts. He confessed because he had lost all sense of normalcy, all sense that he had control over himself. He was just a little bit crazy. So that's their argument about that. And by the way, I feel sure Judge Gull will allow those confessions in. I think just about any judge would. And it will be up to the defense to explain to the jury why a confession isn't a confession. But may I add, too, there were other people who confessed too, who are not up for trial here. And so, and that's part of what we'll go over when we do our deep dive into the third-party culprits. All right, looking for question marks at the beginning. Sometimes I get just a little word or two. I'm like, I wonder what that conversation was about. All right, Carmina, why did the judge remove the defense team? So the judge argued, and you know, that's a whole nother video that I already have sort of a bunch of stuff lined up for it. Just that the bad blood in this case is amazing. Bad blood being an expression that at least I'm used to here from these parts, these here parts, where it meaning people not getting along, like really not getting along with each other. So the prosecution, the defense, the judge, wow, just the prosecution and the judge are on one side, the defense on the other. The judge made very harsh statements about the defense, and these statements were just aimed super hard at the improprieties of the way the defense acted. She was upset about a number of things, but we will cover that in detail. That she believes that they leaked documents. She believes that they treated documents very cavalierly so that someone else could leak them, things like that. She was very upset with them. Camilla, do you enjoy reading? What, for example? I do enjoy reading. I used to read a lot more than now. I watch a lot of YouTube. Times have really changed, haven't they? But I love reading. I love reading any kind of fiction, just about. And I actually really like science fiction, believe it or not. I think that's a lot of fun. All right. Eileen Santu would love you to cover Delphi in Indiana courtroom. To be honest, so would I. I just am absolutely fascinated by this whole case. So I would like to see it too. I just would like to see it unfold. I would really like to know more about. I have no idea what I believe. I don't know if I think he did it. I don't know if I think the state is just picking him out of a lineup when in fact either a group or an entirely different group did it. I don't know. I just would like to follow it and learn more about it, because this is one heck of a case. All right, one more. Do you think, Danielle, do you think any chance Gull simply denies the state's motion like she did the 4 from the defense? I don't think she will just deny it. There are elements to it that she should consider. She should consider, for example, have they presented enough evidence on this person or that person? And she should actually look at, is there a connection between this person and the crime? So some of that, I think she really has to look at. It's a very general, very brief motion. It didn't do a lot of argument from the state. And then Richard Allen has responded to it a bit more broadly because they've done it 3 times plus a hearing. So I think that what she is going to have to do is take it bit by bit. Some of it, I think, it's just too broad. I think she has to deny it. But some of it is something where she has to say, okay, yes, I do feel like I need to consider this. I need to look at this. And whether or not Richard Allen is successfully connecting this particular third-party perpetrator to the crime. Is there enough there for him to be allowed to present that evidence? So I think there has to be at least some discussion about that. All right, so excuse me, we are celebrating this week. This is our last day. We've been celebrating 25 million views on the channel, which is overwhelming, and for which I am so grateful to all of you for watching. Thank you. And may I say, 25 million is without shorts. That's only long form videos. I've only ever done 4 shorts. So if you see that, those are like vintage. Only ever did 4. So we have a special outro done by one of our 2 moderators. Marlon and mamapinks are our moderators. And Marlon did this for us, this special outro. Remember that on Wednesday, we're going to have a special members only event after our regular live stream. I'm also going to be doing I'm going to be going tomorrow night at 7 p.m. Eastern with another video. So I'm going to be doing more than Our usual is Monday, Wednesday, and Friday at 7 p.m. Eastern, but we're going to be doing a little bit extra this week. So I will see you tomorrow night at 7 p.m. Eastern.